Today in this video we are going to discuss about jurisprudence and legal theory, and in jurisprudence we are going to discuss the topic principles of liability. Liability means responsibility. Whenever a wrongdoer commits a wrong to harm the others, the wrongdoer should should have the responsibility of the liability, or the wrongdoer should be compensated. That is the principle of liability. So here the liability is the bond of necessity between the wrongdoer and the remedy. So the liability means it should be the wrongdoer should compensate the other who underwent some suffering or damages due to the wrongdoing. That is called liability. So now we will see the theories of liability. Three cases where duties are not specifically enforceable. So in some of the cases we cannot enforce the duty. That is, one is that is duties of imperfect obligation. For example, the time barred debt cannot be enforced. The debtor cannot be, the creditor cannot enforce the debtor to clear his debt if it is time barred, say more than 3 years. So that is called duties of imperfect obligation. Second thing, duties transitory in nature. There are two types of duties. One is called continuing duty and another one is called transitory duty. When the transitory duty means it is short-lived in nature. So whenever certain libel or the libel is committed, it is transitory in nature. So it has to be compensated. That is called duties in transitory nature. Say for example libel, in the case of libel and assault. Then the next thing is specific performance in expedient. That means, for example, when a person promises to marry another, that cannot be enforced even if he fails to do so, but the affected party can claim the damages which he or she suffered. That is the specific performance in expedient. And another thing, theories of penal liability. The Latin term actus non facit reum nisi mensitria. That means there are, while committing crime, it should accompany two things. One is called the intention and the performance or the action. That is mens rea and actus rea. If these two things are combined, then only it constitutes crime. That is, one has to hatch the crime in his mind, and that has to be implemented. That is called actus rea. Then some exceptions are also is there. That is, mere negligence is not punishable, and offences of mere, suppose if it is proved that the person who does the duty is negligent, means if it is some of the negligence are excusable, and offences of strict liability, whether the action or the duty ends in some serious actions or serious thing, then it comes under strict liability. Then next is concept of acts. Whether the acts may be positive or negative, or some of the actions are voluntary or involuntary, For involuntary, for voluntary acts, it is the liability rests with the person, but involuntarily something happens, it is beyond his control, then the liability is not, cannot be claimed. Uh, then damnum sine injury, and another thing, intentional act and unintentional act. Certain things, intentional act is liable and unintentional acts are not liable. Then two classes of wrongful acts, one is called civil liability and another is called criminal liability. Civil wrongs are usually the damage is claimed. In case of criminal cases, it is the punishment is the liability. Then damnum sine injuria, harm done to an individual and harm to community. Damage without injury, that means the no legal injury but damage is there. In that case, we cannot claim it as a that is the liability do not rest there, because for a say example, in a competition act, one person open a stall and another person opens another stall, the same commodity and other thing, we cannot ask them to not to open the stall of same commodity, because it is up to the competition is always there, then they can do anything. If damage occurs to one body or non-stall, he cannot claim the damage caused by another stall. That is called damnum sine injuria, and it falls under harm done to an individual, harm done to community. That is two types. Place and time of an act. Act is done in one place, done partly in one place and partly in another place. Say for example, an Indian do harm to another person, say in Pakistan territory. So it has taken place in India, whether it is not in India, not in Pakistan. So the liability, the action can be done either in Pakistan or in India or in both places. That is called act in one party. Act is done in partly in one place and partly in another. Where there is an omission to do an act, whenever there is an omission to do an act, then the liability rests. And the concept of causation, usually the concept of causation is man's liability only if damage is the result of his own act. So because of the because of his own act, if the damage is caused, then the liability rests. That is called concept of causation. Mens rea means guilty mind of three categories. One thing is guilty mind means the having the mind of doing harm to others. That is called guilty mind. One is called intentional or reckless wrong, wrongs of negligence and wrongs of strict liability. So intentional or reckless wrong. Intentional wrong is always liable, and wrongs of negligence, it may be according to the severity of the case, it can be decided. And wrongs of strict liability, it is purely based on actus reus. That is, after hatching the idea, how far it is implemented. That is called actus reus. Then the exception to mens rea. Mens rea means hatching the criminal activity in mind. For that, some of the exceptions. That is, statute itself imposes strict liability. Whenever the statute itself imposes liability, then there is no, the mens rea is not taken into account. Say for example, PFA, Prevention of Food Alteration Act. that do not need the mens rea. Whenever the food particles contains that is beyond or adulterated, then naturally the course of liability rests with the person who sold the adulterated food. Then where it is difficult to prove mens rea, in some of the cases mens rea cannot be proved. In such cases the mens rea has its exception. Cases relating to public nuisance. In case of public nuisance, the mens rea is exceptional, and ignorance of, for the simple purpose of I don't know the law, it is not exceptional to the action. So one has, it is expected that one should know the law. If he says that ignorance of law is no excuse, and summary mode of enforcement, it is the criminal in form or civil in form, it is for enforcement of right. And intention may be there while doing a crime. It may be foreseen consequence and probable. Some of the things are foreseen. Whenever a person does the duty, you should see the foreseen, what are the things will happen. That is called foreseen consequences. And when he fails to do so, he is liable. Like that, probable consequence. Sometimes the probable consequence also should be felt by a person who does the duty. And if something goes wrong, then he is liable. Then transmigration of malice, that is the responsible for the harm. A person holds responsible for the harm, that is transmigration of malice. Even if they intend to harm someone, suppose if he intends to do harm to other, he will be, suppose A wants to beat B, but sometimes that beating is felt by another person C, then the A is responsible. That is, even if the intent to harm someone, but the harm is done to some other, then he is liable. Then motive, reason, whenever a person has the motive to commit a crime, then he is liable. And malice, that is when a person enjoys in harming others, then that is liable. And negligence. In negligence, there are two things are taken into account. One is called absence of care and duty to take care. Both these things should be there. If they fail to do take the importance of absence of care and duty to take care, then they are liable. Then theory of strict liability. Then strict liability can be enforced where there is mistake of law, mistake of fact, and inevitable accident. Mistake of law is a serious consequences, and mistake of fact when compared to mistake of law is not that much seriousness. And inevitable accident also receives the liability. That is, accident cannot be prevented. That is called inevitable accident. Then vicarious liability. Vicarious liability means for the harm done by the servant, the owner is responsible or the master is responsible. That is called vicarious liability. Say for example, a person taking the car during duty time, the collector car to the garage, and during the course of his duty, if he does the wrong, then the liability rests with the collector, that is the state government. That is called vicarious liability. Mention law of criminal liability. The criminal liability can be judged by the magnitude of the crime and measure of the crime, how far the intensity of the crime. Basing upon the crime, the measure of the crime and the intensity of the crime, the liability rests. So, and then the last one is the civil liability. For the wrongs committed by a person is of civil nature, say it may be the non-performance of contract or some land disputes, in some of the things which invites damage to the damage as the compensation. That is called civil liability. For that compensation is done. That is the ordinary damages. Whenever a contractor fails to, say for example, a transporter fails to deliver the goods to the intended place, or it is delivered late, then damage, he has to incur the penalty, that is in the form of damage. So he has to compensate the person who is affected by the delayed sending of the goods. And then other ordinary damages. Some of the damages are called ordinary damages. Some of the things are called special damages. Some damages are exemplary. So to give punishment, exemplary damage is awarded. And sometimes the person who does severity of nature in case of civil cases, in the case of land dispute or in failure to execute contract, then vindictive damage is made. That is, vindictive means that is a severe punishment is given in the form of damage. So these are all coming under the principle of liability. With this we conclude this video.